Let's think about this for a second. Who owns your face? Not, the one attached to your head, but the image of it. Can you sell it? Can you license it to just one company? Today, that seems kind of obvious, right? But it actually took a massive courtroom battle over bubble gum and baseball cards to figure it all out. And in the process, invent a right that now powers a multi-billion-dollar industry.
Okay, so let's dive right in. At the absolute heart of this story is a pretty simple fight between two companies. On one side, you have Haelan Laboratories, and they're saying, hey, we bought the exclusive rights. We have a contract. But then Topps Chewing Gum comes back with this really fascinating legal argument. They said, you can't buy a face. The right to your own picture, well, that's just a personal right of privacy. It's not property you can sell. So let's set the scene. Picture this. It's the early 1950s. Baseball is king. And inside every pack of bubblegum are these little cardboard treasures, pictures of the game's biggest stars. Now, for companies like Haelan and Topps, controlling which players showed up with their gum, that was everything. This wasn't just about gum. This was about winning over millions of kids across the country.
Haelan's game plan was super simple. They went straight to the source, the players, and got them to sign contracts. The deal was crystal clear. Haelan, and only Haelan, could use a player's photo on their cards, and in return, the players promised they wouldn't go sign a similar deal with any other gum company. Seems straightforward enough, right?
Well, yeah, it was simple, until a rival decided they were going to play a different game entirely. So here's the kicker. Topps knew about Haelan's exclusive contracts. According to the court documents, they deliberately went to those same players and talked them into breaking their promise and signing a new deal. Just like that, Topps starts printing cards with the very same players, and boom, you've got a legal showdown. And this right here is where a simple business squabble turns into a landmark legal case. The fight wasn't really about contracts anymore. It was about this huge, fundamental question that nobody had a good answer for. Is the right to use your own picture something you can actually sell? Is it a commercial asset? Now, to get what Topps was trying to argue, you got to understand the law back in 1953. The only thing on the books was something called the right of privacy. And what's really interesting is that this law was all about protecting people's feelings, preventing the emotional distress of having your photo pop up somewhere you didn't want it. It was seen as something deeply personal. So Topps lawyers built their entire case on this idea. They argued that since this right of privacy was personal, something you couldn't sell or transfer to a company, Haelan's contracts didn't really buy anything tangible. At best, they were just a promise not to sue. So Topps claimed those exclusive contracts, they were basically worthless. This put the court in a really tough spot. I mean, if Topps was right, then basically any celebrity endorsement deal could just fall apart. So what happens when these old laws slam up against brand-new ways of doing business? And what the court did next was amazing. They didn't just pick a winner. Nope. They changed the game entirely. In this landmark decision, Judge Jerome Frank looked at the reality of the situation and decided, you know what? The law needs to catch up to the real world. The court's solution was to invent something completely new. They called it the right of publicity. They said, forget about the right of privacy for a second. There is a separate right in the publicity value of a person's image. This wasn't about hurt feelings anymore. This was about cold, hard cash. It was a property right.
And Judge Frank's reasoning was just so practical. He basically said, come on, let's be realistic here. Famous people aren't upset when they see their face in ads. They'd feel sorely deprived if they stopped getting paid for it. He argued this right would be totally meaningless if you couldn't sell it exclusively.
So let's break that down. Think of it like this. The old right of privacy, that was a shield. It was a personal defense to protect you from emotional harm. But this new right of publicity, that's a key. It's an asset, something you own, that you can use to unlock the commercial value of your identity. You can sell it, you can license it, it's yours. Okay, so creating a whole new right is one thing, but the court also had to lay down the rules of the road. What happens when a company like Topps knowingly messes with an exclusive deal? The logic they laid out was crystal clear. If Company B knows that a player already has an exclusive deal with Company A and signs them anyway to use their picture, well, that second contract is just no good. The court's actual words were utterly invalid, and that gave real legal teeth to Haelan's exclusive deals. So, a bubblegum fight from the 50s. Why should you care? Because, and this is the incredible part, the world we live in today, especially online, was literally built on top of this decision. Mark this date down, February 16th, 1953. This is the day the whole idea of owning the commercial value of your own image was born in American law. Before this, a total gray area. After this, it was a recognized, sellable asset.
You can draw a straight, unbroken line from this one ruling to the explosion of athlete endorsements in the 70s, to actors licensing their digital selves for video games in the 2000s, all the way to today. The entire creator economy, every sponsored post you see from an influencer, is fundamentally built on the principle that they can sell the rights to their own publicity.
Just let that sink in for a minute. Every single time you see a famous face selling a car or a pro athlete as a playable character in a video game, you are looking at the direct legacy of Haelan versus Topps. A fight over cardboard pictures and chewing gum laid the legal foundation for all of modern celebrity and influencer marketing.
And that leaves us with a massive question for our time, doesn't it? This case gave us the rules for a person's physical face, but now, in an age of AI deepfakes, digital clones, and virtual avatars, who gets to own and control a person's digital identity? The next great legal battle over faces, well, it might already be here.